And one. That's a two. Oh, all right, we are there. Isn't it awesome? I like it. All right, good evening, everyone. Do I need to cut the lights on? Yeah, I'm going to go ahead and cut the lights on before we get started. All right, good evening, everyone. It is Thursday, May 12th, 2016, 6:30 p.m. I would like to call the Champaign County Racial Justice Task Force to order. Can we start with the roll call, please?
Mariam Arahim. Sarah Balgoyan. Lynn Branham. Pam Burnside. Brenda Butts. Sam Bindum.
Present.
Rosita Bird. Ellen D. Alex Evans. Amy Felty.
Here.
David Harbor. Here. Ryan Hughes, present. Artist James. Here. Esther Pat.
Present.
Carolyn Randolph.
Here.
Henry Ross.
Here.
Kevin Snyder.
Here.
Susan Silver.
Here.
Demario Turner. And Gerald Walter.
Here.
Thank you.
Okay, the next item on our agenda is the approval of the agenda. I would like to make a modification under presentations. We have a Barbara Kessel with the court watch that I would like to add. Say it again. No, she did not present last week. I emailed her earlier this week.
Oh, you're saying.
I would like to add her to the agenda, the current agenda under presentations.
Oh.
Are there any other?
You gotta make a motion.
Yeah, I don't think I can make a motion.
I move that we adopt the modification of the agenda.
Is there a second?
Second.
All in favor?
Aye.
All opposed, the same? Motion carries. Our next agenda item is the approval of the minutes for April 26th.
I move to approve the minutes.
All right. All in favor of approval?
Aye.
All opposed? The motion carries to approve the minutes from April 28th. Welcome.
Quick
Yes.
question, are our alternates supposed to be listed when they're present? That's right, right? We don't have any alternates anymore, right? They're, okay,
Correct.
sorry.
All right. For those members of the public, if you would like to participate, there are white sheets at the back of the room that you can fill your name out on and bring them up front for public participation. Welcome. Okay. All right. At this time, I would like to welcome any public participation. Again, if it is that you would like to address the task force, there are white sheets in the back of the room that you can sign your name on and bring them up front, and we can you will be able to address the task force. Oh, okay, all right. Well, if there is no public participation, we will move on to the next item on the agenda. Task force member updates. Uh, A couple of things that I would like to make note of. We've had a couple of resignations. We had, let's see, Kim Bryan.
That's it for this week.
No, there was two more.
Yeah, but we already.
You already
addressed
took
those
care of that?
Last week.
All right. And the alternates will be replacing them, L&D and, who's our other alternate? Rosita Bird, thank you. All right, those will be replacing our members who resigned. All right, our next item B is a discussion of the structure of the community events. Is anyone from the committee going to, or the group?
Sarah was going to be here. She had a report, and I did not put it out, so I'll try to read it the best I can. Ma'am, you can help me out. You can help me out here. A couple things. We came up with some dates, and we're talking about June the 9th or the 16th, which are Thursdays, 2 dates. Let me clarify something first. We're waiting to get confirmation from the space, maybe Love Corner or Salem Church, whichever. So we wait on confirmation on which one of these dates will work best for him. So I start over. We're looking at Thursday, 2 dates, 9th and the 16th. And I say those are the dates we're looking at, but we're only talking about one event, so I want to make that clear. The other date is, would be Saturday, June the 11th. There she is. Sorry. June the 11th and the 18th. So those are the dates that we're looking at. On Thursday, we're talking about possibly having it from like 6 to 8, something along that line. And on Saturday, we're talking about somewhere around 11 to maybe 1. So that's kind of what we are talking about. When Sarah get situated there, I'm going to turn it over to her. So, but yes, soon we get confirmation on the date, I think we can go forward.
Excuse me. Oh, Love Corner is available for the 9th and the 23rd, 6 to 8.
Okay,
But not the 16th.
I haven't checked on the 16th.
16th is our meeting.
all right, I didn't hear all that. What's with the 16th? No? Oh. Okay, oh, okay. What did I say, 9th and 16th? 23rd, yeah, thank you.
We
Yeah.
could.
Yeah, so it'll be 9th and the 23rd is what we're talking about on a Thursday. And on a Saturday, we're talking about the 11th or, what was it, the 25th? What we got here? 25th, yes, it's right on the sheet here. Yes.
If Love Corner is available on Thursday nights, then
The 9th or the 23rd from 6 to 8.
Did you check on the Saturday?
They didn't have the Saturdays available.
Okay. I'm gonna turn it over to Sarah
One moment.
to finish the report.
Oh, did you have a comment or question?
just a comment. 6 to 8 works fine for me, but people with children tend to not turn out to things that come out, that start at 6. I mean, unless we're providing food, because they got to feed their kids. And so I'm just concerned that if it starts that early, we might be reducing the potential, population of attendees, at least the population of people who have little children. So that's something to think about, maybe make it a little later in the evening.
But couldn't people come anytime during that time so they could get there at 7 and be okay?
Or,
Sure, I mean,
okay.
yes, public.
I mean, we're open to times. It's just a suggested time, so whatever feedback people have on that.
If I could just make one more comment, if you were going to have a time, generally when something's 6 to 8, it's, show up at 6 and you just sit for 2 hours. If the deal is drop in any time between 6 and 8, the publicity should actually say that, drop in, kind of like with an open house, drop in any time between 6 and 8. Otherwise, some people just look at 6 o'clock, I can't do it, and they're not going to come.
So do you suggest 7 to 9?
I think that's better, or at least, or even, I don't know, I mean, I don't know. I actually don't have small children. It's just that so often comes up in organizations that the people with the kids just say, oh, well, no, we can't do that because I just, I got to feed the kids and all that. So
Yeah.
I don't know if there's anyone here young enough to have small children. What do you think? Yeah, what do you think, Carolyn?
I actually think that 7 to 9 might work, but if you wanted to do 6 to 8, I think we talked a couple weeks ago about taking a donation up. So maybe you can provide some snacks or something, or have something available for families that do have small children. There is a cafeteria in the church. So maybe you could provide something. The money could go towards having food available.
I think that was, the ACLU was willing to contribute, and maybe the Bar Association, and snacks were definitely on the plan. Potentially, also, Artis and I, we kind of briefly mentioned possibly paying someone to provide childcare. So, without knowing RSVPs. As far as format goes, do we want to jump into that, or were there other thoughts on dates and times and stuff?
What's the address?
1109 North 4th Street, Champaign.
Let me ask the committee this, because my preference is like on a Saturday. That's just my preference. I'm just curious what other people think. I do have a call out to Salem Church for possibly a Saturday. That's just me. A couple hours on a Saturday would work best for me. That's, anyone else have any preference, or we really don't care?
I'm inclined to agree that I think people are more likely to turn out on Saturday than in the evening. But it depends, different people are different, but it's mainly about if there's a place available, because if there's a place available for us for Thursday nights, then there isn't one for Saturdays. But yeah, I think for some people, it's just easier to get there on Saturday than to rush into things at night. Even during the summer? Yeah, well, summer nights are, Pam said even during the summer. If this were winter, then I would definitely say, Saturday would be better. But in the summer, you're competing with at night, there's stuff, there's a lot of things at night too, because it doesn't get dark. By June, it doesn't get dark till, 8:45. So there's probably no perfect time, but I can see the advantage of Saturdays.
And I also want to mention that, again, a weeknight, particularly, we probably would want to push it back to 7, because 6 for working people, that cuts into the time off work to get there. So if we decided on a Thursday, I would suggest the 7 o'clock. But if we could get a Saturday, I would strongly suggest that also, because even though there is no school, still, it's a weeknight. So we could take that into consideration. I don't know. But again, either night we choose, we want to make it most accommodating for our audience. And Saturday might be a better time, a better day.
Henry, was the church just not available those 2 Saturdays, or are Saturdays kind of out for them in general?
No, not in general. I'm sure they have Saturdays in July, maybe. So I can check on other dates.
We were talking about we're having more than one of these. We could have one at Love Corner on a Thursday night, because they've got the times open, and then we could schedule something on a Saturday if either Love Corner or Salem or someplace else, late, like in July or a little later then.
I like that idea.
Yeah, it feels to me like we should, we've got a space and we should just give it a shot and see how it goes and work on maybe a Saturday date too. But I don't know, I don't think we have to vote necessarily, but like I'd love to see a show of hands if that's an okay way to go or some consensus around that. So we can secure Love Corner and get a flyer and all that good stuff going. Any thoughts? Thumbs up, sideways, down? All right. And it's the large sanctuary that'll be available, the new building?
That I'm not for sure of.
Okay. I think that's essential. I mean, potentially we'll have a lot of people, so, and then we want small enough places where people can have dialogue without overhearing, being too loud, so having this, the space to move around or be spread out, so I think that big sanctuary would be ideal, and, we could maybe anticipate 70 to 80 people, potentially.
70, well, they have two churches. The 1109 4th Street Church, it will accommodate more than 70 people. I mean, it's a nice church also, and it's known in the community, but I'm sure if we needed to use the big church, then they would accommodate us.
Okay, whatever works for space, just being able to have chairs that can move into small groups and, that kind of thing into space is, I think, okay.
Yeah, if you want to pick a day to come look at the church and we can sit down and talk, figure that out.
All right, thanks. So our group talked a little bit about kind of the overarching goals of the dialogue. Oh, right, did we name it? Community dialogue, what did we name it, Artis? Community dialogue, are we, a suggested name? Yeah, community dialogue about racial injustice or something in Champaign County. That's a working title, of course. And so we kind of thought that that's a good start for the goals. We want to provide space for people to tell their stories and to bring up their concerns and start to build relationships in the community between us and the community and gain support for the work we're going to do and get input on recommendations that we'll hopefully eventually be doing or some action steps or some next steps from the community. So we kind of saw those as the goals for the event. The proposed format that we are bringing to you guys is, 2 hours for the event, starting with an introduction, one of us and, maybe one of the sponsors or the church or a representative from another group would help introduce and welcome people. Why are we here? Thanking everybody who's contributed, give a brief overview of the task force, how it came to be, when we got started and our mission. And if we could try to summarize the data that we've heard so far in a couple of minutes, I don't know if that would be possible at all, but we could just mention that we've heard data from and reference different reports and community groups that have provided that for us. And then break into small groups, 8 to 10 is kind of the max, I would say, on that. And this is providing that we have more than 8 or 10 people show up. And we're proposing using a small talking circle. So talking circles are an indigenous practice that helps provide a space for everybody to talk. It reduces and gets rid of all titles and power struggles and all of this, so everybody becomes equal and you're all face to face like us right now, and so you're able to have that conversation. And we would provide, one of us or somebody from the church or another group could be kind of the facilitator of the group just to get people started in the dialogue. And you'd have some questions like, who are you and why was it important for you to come here today? And with that process, stories are going to begin to come out, and the facilitator or the designated person would start taking notes, or we'd have some chart paper or something where people could be taking notes as a group. We'd want to ask them, what is racial injustice? What does racial justice mean to you? Because assuming that everybody has the same definition could get us, going down the wrong path there. And then describe any personal experiences that you've had, people that are related to you, friends, family, things you've seen related to racial injustices in Champaign County. What happened? How did it affect you? Outcomes? Was it resolved? That kind of thing. And then moving into, how can we make changes? What do people think they, are tangible changes that could be done, or the most important ones, or the most vital? And keeping the questions kind of vague enough that that we get the input from people, but also targeted enough that we're not talking about things that aren't related to racial justice in Champaign County. And then come back kind of to the whole group, not necessarily have to move, but every small group could provide a little bit of a summary of what they talked about, and maybe share some of their notes back to the larger group. And somehow we'd capture that as well. And then acknowledge everyone and thank them for their time. And, if we have another event set, invite them to that, or share the information, or invite them to our next meeting, or whatever we want to do from there. So that's the general proposed format, and open to feedback and thoughts.
I had a question about the facilitators. Have those been designated, or how is that going to occur? What's the process for that?
I think this is a good group to start with, and, we could all potentially be there as facilitators. And, at the beginning of the event, we would just, we'd identify them ahead of time. We need to firm up location and place and time and date and all that first, I think, and get some volunteers. And then, we'd have the list of questions either up or give them to people and just say, these are your guiding questions. But, the job wouldn't be, it's really about the community, the group, having the dialogue. So I think the facilitator job wouldn't need to be a trained position or anything like that. And also maybe the sponsoring organizations. So we've got NCAM and NAACP, and if folks from the church want to help, that could be a good addition to that. That's my thoughts.
So even as facilitators, we're still part of the community. So I think finding a way to kind of break that barrier between us and them, I think would be really important. One of the suggestions I have was at the introduction, also talk about the format of how it's going to play out for that evening so that people have a heads up, kind of a warning about this is how it's going to break down. And then I would allow, when you get into the small group dialogue, rather than necessarily having a facilitator welcome, maybe have a question or have your questions posted and give people a chance to kind of write down some of their responses or brainstorm. For those who may not be interested or be as vocal, it'll give them a chance to kind of process for a moment before they start to have the conversation. So those are my 2 suggestions, or 3.
I just wanted to suggest, it sounds good, but when talking about it, you keep using the expression racial justice. I think it's real important in the publicity to make clear that we're talking about racial justice issues in the criminal justice system, unless we want to open up to more things, because there are a lot of people who have issues, racial justice issues, other than with regard to the criminal justice system, and it should be clear if what we were looking for is criminal justice, which I think is what we are. I mean, like, for example, what's going on with the university, in facilities and services, and then in the environments, in places of employment, I mean, other than the university, those are all racial justice issues too, and so we should just communicate, what it is we're focusing on. And also, I think just because there's so many meetings and events that people go, and what you do is listen to other people. Anytime you're having something where you want people to come speak, I think the publicity has to say something like, we want to hear from you, or something to make clear that the purpose of this event is to get folks in the community to come talk about their experiences, because otherwise people just might not.
Have we, have we thought about, we'll need to post these, I'm assuming, as open meetings, because we'll be there a number. So we need to post it on the website, and we need to post it on the locations of the meeting, and I don't know if we need to post it here. We'll have to ask as our home office. And then we also need to have someone come and act as secretary, because it'll have to have minutes, notes.
Excuse me. I've been thinking about this all week, and I was thinking that I'm hoping this meeting doesn't turn into like a police bashing type thing, because I don't think that that is the primary problem. I think it's the things that are leading up to the criminal justice system. So when we promote this, I hope we're not promoting it to be a police bashing type thing.
I think that's one thing about if we're promoting it as solely in the criminal justice system, that potentially could drive the voices that show up. And we have as a group talked a lot about the school to prison pipeline and housing and employment and other things. So I'm nervous to narrow, my opinion is I would rather not narrow it down ahead of time, but, and because I think we could end up, well, it could go either way. So I hear what you're saying, Esther, about that, and I don't know how to balance it.
I'd say that if we put out something that we're going to have, we want to hear about what this is the subject of this task force, which is racial justice in the, racial disparities or racial justice in the criminal justice system. If it turns out that everyone who shows up is a person who thinks it's the fault of the police, then don't we want to hear that? I mean, the idea of trying to structure this in a way so that we don't get, I mean, I understand that you're hoping we get more than police bashing, I agree, but if what we want to hear is from the people, then I think that, we should be prepared for that. And I'm not against talking about other racial justice issues, it's just, imagine that we have a meeting and you've got people coming in talking about rental housing issues that have nothing to do with the criminal justice system, just their personal experience with rental housing, employment definitely, because that's there are a lot of complaints about hostility in the workplace or about unfair and promotion, all that. I mean, if you want to hear all that, then fine, let's just keep it open. But I think, and then who knows what it'll be, but I wouldn't be surprised at all if we make it that big, that's what people will talk about. So if we just want, we could be trying more specific, like we could say, we could say about racial disparity in the criminal justice system, courts, police, schools, list a bunch of different words to try to get the broader view of what we mean by the criminal justice system. But I do think that that our purpose is to be focused on criminal justice, so we should somehow communicate that to people that that's what it's about. If nothing else, so they don't show up disappointed that, gosh, we're not going to be dealing with, employment and the income disparity by race and stuff like that, because that's not what we're talking about.
I too am concerned about the fact that it would get to be just police bashing, but I think we somehow have to figure out a way to help people remember that the police is the initial contact to the criminal justice system. And from there, we go into the courts, and then we go into probation and sentencing and all kinds of things. And quite frankly, that's where I see we need to explore in addition to the police thing. I think that historically, we haven't really looked at a lot of the policies and procedures, the institutionalized racially unjust practices that are going on in Champaign County. And I don't know how we're going to get to that unless we ask more targeted questions, have something like Esther said, bring up just a list of words or a question that says, okay, police, okay, now we're going to look at the court system, now we're going to look at probation, whatever. But yeah, I share Henry's concern about that, and I hope that we can figure out a way to broaden it a little bit.
I also share Henry's concern, but at the same time, I think we have to remember that this is not the only one of these we're going to do. And some of which I'm hoping will have specific, specific shareholders within the other communities, including, hopefully police officers, prosecutors, public defenders, people who might not be overly represented at this one, but like I said, this is not the only one of these we're going to do. So I think we should sort of see where it takes us, and maybe we'll be better prepared for next time. But I don't want to steer the discussion too much. I do agree with Esther that we should, part of what we're having these is to actually hear what people have to say.
We might be able to use the language right from the resolution to help do that. It says, looking at racial disparity in the criminal justice system, take positive steps to address issues of racial disparity in the jail population and the criminal justice system. And the findings should include a list of recommended actions to address said disparity. So that might help a little if we introduce it that way.
I would prefer that we use our mission statement rather than what was sort of foisted upon us by the county board.
Well, if there's some good balance, that's fine, but if we direct it at the beginning where we hope to gather information and we hope that people will speak to that, that might help focus it.
And oh, I'm sorry. We are hopeful that it won't turn into a police bashing, whatever that means. But on the other hand is most people's entree into the criminal justice system is through the police. And the disparities in how laws are enforced leads to the disparities in the court system, leads to the disparities in the probation system, leads to the disparities in the broader society. So it might be one of our tasks to, in addition to listening to those stories, to assist in identifying how this then leads into that. I would like to think that even if a person shared that story, we want to say, and as a result of that, what happened? Were you on parole? Did you have a criminal record? And whatever. I think it's unrealistic for, certainly with this our first event, not to have people need to relate their stories about their interactions with the police. Not to focus on that completely, but it's sort of like you can't talk about a baby being born without talking about a pregnancy.
So I don't want to assume what we're talking about when we say police bashing, but I have a problem with what I think is going on with that, because we got to remember, like, we're kind of going at this like as researchers. So that's a very biased way to phrase it, because if we go into it and we're listening to those stories and then we categorize this person as police bashing, that means we discredit their story before they even tell it. So I don't know if it's just something that I want us to address as a committee or just something that we all need to think about individually. But if someone feels bashed by the police and they come tell us how they feel bashed by the police, then that's how they feel. And I think that we have to be able to analyze that data, those interviews, those discussions from a, I don't like the word objective, because it shouldn't be objective, because the police have way more power. So we need to be more of advocates in our position. So there's just a couple things that I want us to think about as we kind of go along with that. And if you meant something different by police bashing, feel free to let me know, but it just kind of seems a little.
Yeah, well, I guess I'm saying police bashing, as a lack of a better term. But basically, I know that one of the biggest problems facing the criminal justice system is recidivism. So I think that we should be looking at issues that are leading people to recidivate. Employment, housing, A lot of things lead up to the crime, but I definitely don't believe that everyone in the or everyone in the county jail is innocent. There are people over there because they had to do what they had to do to survive when they couldn't find employment or housing, and then that's what caused people to re-enter the criminal justice system. So, yes, I do believe the police are a very big part of it. I'm an African-American male from the north side of Champaign. Believe me, I know they're a big part of it, but they are not the biggest part of it. I think schools, what goes on in schools, kids being kicked out without, proper procedures being handled. Like I said, back to the employment thing, issues that I've had personally. So I don't think that all police officers are bad. I think actually the relationship between the community and the police officers is on the upswing. So I think we should more play on that and, look to build the relationship with the police instead of tearing it down. And I know that everyone in there won't come in with that attitude, but if they think that's what this meeting is about, if they think it's to talk about the police, then that's what they're going to come in and do.
And Alex, would you be willing to help us think about how to think about this as researchers and like capture the dialogue, like the key points, and maybe we could have some ideas about that? Because I think that's a great point to, how are we going to process this? And we're all going to have different conversations in different groups. And so how do we bring that back and do something with it? That'd be great. Thank you.
Okay, any other questions or comments about the structure? So the work group will continue finalizing plans and then report back out?
Yeah, I think we'll firm up a date and get a flyer going and request support from you guys for facilitation, for participation, for spreading the word, for whatever else we'll need support for. So I don't know if we can do that over email, so maybe at the next meeting.
Are we still going to leave open the option to have a second meeting if we can find a space for that?
I think so. I think if we can find a Saturday space, and I think it'd probably be good to do it at a different location just to mix it up some, maybe in Urbana or Rantoul or something. Any thoughts on that?
I'd hope we would have more than one of these events and, like keep planning, don't just put everything on the one and let it go. We can also learn from the first one as to what to do.
Okay. We will move on to item C. Task Force Member Hughes wanted to discuss a discussion on the resolution regarding marijuana possession fines.
Thank you. As you guys know, I brought this topic up a couple of times in the past few meetings. I think that this is an important subject in the news that we need to, at the very least, recognize and perhaps discuss a little bit here. And I'm hoping to do that by opening up a short discussion with some context and just share some information kind of on what happened in the past few months at the Urbana City Council as it relates to marijuana fines. I did say that I would draft a statement of support that we could perhaps adopt. I did not do that. I'm not going to offer a motion to do that. If someone else would like to, that's certainly something we could discuss. But after thinking about some of the apprehensions that a few members had last meeting about what that might mean in terms of perception of what we're doing as a task force, I decided that's not something I wanted to pursue. But with that said, I still think it's important that we discuss this and recognize it, and that it goes on record that we did discuss it and acknowledge it. So So without further ado, if you don't know, a couple of months ago, Councilmember Ammons of Urbana City Council presented an idea to remove the fine for possession of marijuana in Champaign, in Urbana. This is important because of why he wanted to do this. This came out of the Urbana Traffic Stop Data Task Force. One of the recommendations of that task force was to add a moratorium on all marijuana-related citations from traffic stops. And that's simply because of the racial disparities that have been found in those traffic stops and in subsequent actions following up on the traffic stops. So it's important to note that this issue came out of a very clear racial disparity that had been studied in a task force just like ours. So it was a clear and specific recommendation that was presented to the Urbana City Council. Members have said that they're going to work on adopting the recommendations of this task force, and Councilman Ammons introduced the first step in that with relation to the marijuana fees. What then happened was, over the course of a month, the City Council discussed the issue significantly. It was a hot topic. They obviously took comments from the public. They took comments from their community members from their districts. They also did some research on the side. I know that Mayor Pressing did some research with some staff members and decided to look at what have peer communities done with relation to marijuana fines. All in all, they ended up passing a resolution to reduce the fee or the fine from $300 to $50. Councilmember Ammons had proposed no fine, and then they talked about a $5 fine, but they were able to compromise on a $50 fine. And regardless of what we think or what individuals may think of the number that they chose, the Urbana City Council looked at their system. They looked at the power that they had to change that system and what was within their influence. And that included marijuana possession for under 30 grams of marijuana. They couldn't go beyond the state governmental oversight or federal governmental oversight. So they looked at what they could do, and they addressed the topic through discussion, public input, and research. And when I first heard about that, I thought that was fantastic. And so I went back and watched some of the City Council videos. And I simply want to acknowledge the City Council for the work that they did, because that's the work that we hope public entities will do with our recommendations, or I should say I hope that comes out of our task force, from our recommendations. And I didn't latch onto this issue because I'm in favor of marijuana decriminalization, simply because Urbana saw a racial disparity and they acted on it. And I think that's fantastic. So as we move forward, I just want to note that I think it's critical that we consider how we can, I guess, present or format or structure our work and our final recommendations and whatever actions come out of this, so that they can easily encourage this sort of action and discussion among city councils or the county or whomever, and also how we can influence that process and carry it beyond the end of our task force. That's all that I have to say on the issue. I could answer a few questions. I don't know too much more than that, and certainly some of you may know way more than I do on the issue. And if you have any comments, I'd love to take them down as well. Yes, Esther.
Well, a comment, I don't mean this to sound negative, it's just an important warning for us along the lines of the recommendations. Yes, the City Council has changed, in Urbana has changed the fine to $50, but that is only for a municipal ticket. When someone is stopped, whether it's a traffic stop or on the street, and they're found in possession of marijuana, the police officer has personal discretion as to whether to write a city ticket or a state ticket. And this doesn't at all affect the state ticket. And so just, in terms of overall recommendations, lowering the fine, I mean, I think Ryan made the point that City Councilmember Ammons did what he has the authority, or got the council to do what they have the authority to do. And I personally think they have the authority to to give more specific direction to the police, but that's really the big, question here, or the topic that everyone avoids, is that there's, the answer continues to be about a number of things. Well, it's up to the discretion of the individual officer. When we ask for where are the written criteria for their exercise of discretion, such do not exist. Monday night, the city council in committee in Urbana voted to lower the fine for possession of paraphernalia, drug paraphernalia. And first, they, at the recommendation of the staff, I don't know where it comes from, was to only lower it for a marijuana pipe. So if it's a crack pipe, you're still major busted, but if it's a marijuana pipe, the idea being that the fine for actually possessing marijuana is $50, the fine for possessing a pipe to smoke it shouldn't be more than possession of itself, which made sense. So, and I think it'll pass at full committee next week. But again, in the discussion, and there was an article in today's paper, and the numbers, the Gazette, pretty much has it right, but the chief of police threw out a lot of numbers, and the numbers there are a little, not quite right. It's like they say they hardly write any tickets, 114 a year. That's a little more than twice a day someone's getting a ticket for this, for having a pipe and no stuff, which to me, that's, in the community of 40,000, I think that's a lot of tickets, especially since they should never be written. But there was misunderstanding, and things, I guess my point is that things are connected to each other. The chief of police made a statement which actually might be true from his perspective, but is not true in Champaign County. He said, well, first, the mayor and maybe one other council member did not realize that tickets are written for, that you can get ticketed for possession of paraphernalia even if you have no drugs. They assumed that the paraphernalia tickets for, you have a pipe with the drugs, and so there needs to be a little education of the decision makers as they were making their decision. But also, someone did ask about a person being charged for possession of the controlled substance if they get ticketed for the paraphernalia, and the chief of police said, oh, no. Well, that's because if the city writes a city ticket, no, the person just have a city ticket. But if the officer exercises the discretion to write a state ticket for possession of anything, well, including like a crack pipe, then the state's attorney has the discretion, and many times in the past has prosecuted the person. People have been convicted and have gone to the state penitentiary for possession of a controlled substance when what they actually were possessing was a pipe, but it had residue in it. And so I'm just saying the part that local governments can actually do on a lot of these things is really very small. And if we came up with a bunch of recommendations that could be done by just the county board and just the city councils, and if every one of those recommendations were followed, I don't think it would have a significant dent at all in the problem we're trying to address. So I would just, as we work on these things, I think we need to think in terms of how, I mean, obviously how we're going to present recommendations, but we shouldn't limit our recommendations of from what we find in our research to what the local governments can do, because the key problem is not something, I think, key problems are, I mean, like what Pam was saying before, we're talking about courts and probation and schools and jails and policing and sentencing, and so much of it is beyond the decision-making power of the county board or the city councils, and so it'd be good if we were separating them out in some way so that we are not refraining from giving the more important recommendations of what really needs to be done, even if the people who we want to change it aren't paying attention to us, like state legislators or state's attorneys or whatever.
Ryan, I just want to ask this question. It seems as though kind of what you're getting at is a political statement of solidarity with this task force and other political bodies in the area to kind of speak towards the types of things that we're hoping to, the direction that we're trying to head into together, and to kind of make some type of discursive or discourse, whatever, to highlight that. And that seems like that's what the more important issue is here. Am I correct? Okay. I like that idea.
Yeah, that was the kind of the initial idea I proposed 2 weeks ago. like I said, I thought about adopting, or coming up with a formal statement that we could adopt, which would show solidarity with the Urbana City Council. And Lynn, who couldn't be here this week, but last week, she introduced an issue that she felt that would be a too early of a strike, I guess, or an action that we could take. And on top of that, it may hurt our perception in the community and weaken our influence later on, simply because it's tied to marijuana possession. And we'd be tied to that and to Urbana City Council, and we may be giving and this is me speaking now, we may be giving preferential treatment to just the Urbana City Council, and we should be also saying we support the work the Community Coalition has done, which they presented on last week, and other groups and individuals, et cetera, et cetera. And it may be dangerous to simply jump onto this single one right away. So that's what I've been torn in between in the last couple of weeks, reflecting on, and I didn't come up with a solid decision myself, and so therefore I don't think I want to propose a motion to adopt anything formal. But
So, like, are we, like, the majority of us, like, do we recognize the war on drugs as like a real thing that's bad? Or is it kind of like, drugs are bad and people who do drugs are bad? No, I mean, I think it's a relevant question, because if as a committee, we're like split right down the middle, like some of us think that drugs are a bad thing and people who do drugs should be put in jail. Okay, then we can't make a public statement with this. But if we all recognize that that the war on drugs was intentionally created for purposes to malign certain specific communities, and every statistic ever about it has done that, if we can recognize that as a committee, then even if it's just the majority of us, then there's no problem in making a statement. But, I mean, that's just me. I think the war on drugs is, like, horrible. But, I mean, that's just me. If it's 1 against 20, I'll keep my mouth closed.
I would just like to say that I think that what you're saying is not subjective. What you're saying is objective fact. I mean, we've seen fairly recent news articles pretty soon after this committee started that said, hey, the war on drugs was started by Richard Nixon, and it was specifically to put down poor people and hippies. And it was the best way to not have to worry about minorities or hippies and them getting any political traction or power or being able to affect elections. So I don't think there's any question that what you're saying is objectively correct as fact. So, I mean, but that's just what I had to say.
And I wasn't here for the meeting 2 weeks ago, but I don't understand, in my way of thinking, I don't know why it would be problematic to acknowledge something as it occurs in real time, rather than at the end of our report and say, oh, by the way, back then when city council did that, thumbs up, guys. As we do our work, I don't see the problem with acknowledging things that are attempting to, within the small purview, the municipal statutes to address that, and it's acknowledgement that this kind of work must go on at all levels all of the time. Not in a vacuum, not in isolation, and that people would see that we're siding with Urbana. I don't understand what that means. We are encouraging removal of racial disparity wherever it occurs, and the fact that somehow this would make the work that we do less credible, I think it would be the opposite. It's like they're paying attention. Something happened, and they could acknowledge it. And acknowledgement is an acknowledgement. It's sort of like if the more we want to encourage the behaviors that we want to see, kind of thing. So to say that us making a comment about it in some way diminishes our credibility or our capacity. Lynn's not here to for me to ask her to elaborate further, but just in my way of thinking, that in no way does that. I think it actually says that the Racial Justice Task Force is paying attention to what's going on in Champaign County.
And I don't have any problem with acknowledging that. And I think also the way you presented this to us here tonight, Ryan, I think we want to acknowledge and commend the Urbana City Council for taking and looking at some data and taking some action, finding a place where they could perhaps do something, and they took the opportunity to do that. They didn't just dream this up, you know, they had data from their own law enforcement agencies brought to their attention, and they said, yeah, here's someplace where we can get started.
Yeah, I think it's a political statement of some sort, a statement of support is, along with what Miriam was saying. I mean, I think we need to act now and acknowledge what the work that was done, especially because it was data-driven and it's focused on racial justice. And then I think I'd like to see us take it one step further and take that statement of support in some way to the other city councils, to the county board formally, and just, you know, or as a public participant, present that so that it's, you know, it's out there that this is something, not just in our minutes. I'd like to see it go beyond that and be one of our action items or some sort. And we don't have to make a formal recommendation of how Champaign or the county would address this issue, but just to acknowledge that Urbana used the data, and the data is probably there for the rest of the county and could be used to make similar changes. And the war on drugs was a bad thing.
Yeah, this is it, you know, this is a chance to suggest to these other units of government that they can also look at the data, because their data is going to be the same. And it's a chance for us to do something, and, you know, I wasn't so sure at the last meeting. I mean, otherwise, what do? We're sitting here and we're waiting to write a final report, you know, and we do nothing until that happens. Here's something that we can say, you know, we're out here and doing something else.
Well, just sitting here at the beginning, well, let me back up. At the end of the last meeting, I was somewhat skeptical about this task force taking a political position. But after listening to the few people that spoke, and you make perfect good sense, that the Urbana City Council looked at the data, and as you've seen that there was a disparity in the writing of the tickets. You know, I done seen the IDOC report too, so I'm aware of this also, and they took action. So thank you guys for commenting, because you did change my view on this, because I was leaning just the opposite way. But right now, you know, just it's all going to depend on how we word this or how we frame it. If we let's say, put out a support for what the Urbana Council did, we have to make sure that people understand that this is what the data showed is happening in Urbana, and the city of Urbana made some change to address the issue. So we support that.
I was just going to make the similar comment that Artis is saying, that how it's worded makes a difference on whether or not I feel comfortable with it. I'm not comfortable with us as a task force supporting legalization of marijuana or any of those kinds of hot-button topics myself, but the idea of supporting an organization that's researched something and determined that there was racial disparity and a result was made because of it, that I'm comfortable with.
I also like the idea, too, that the recommendations, you were mentioning, the recommendations that they made were being listened to. We're going to make recommendations as well. And we would hope that the political bodies that we address and make recommendations to, whether it's the Urbana City Council or other groups, would take our recommendations to heart, and just in the same way they have with these recommendations. The other thing, too, is that we talked about different kinds of forms of racism. This is addressing systemic. This is a law that's passed that affects groups in a differential way, as you were saying. And it doesn't have to be just, a person saying or doing something. Sometimes the systems that are set up and the laws that are set up affect people in a differential way. I like the recognition of the fact that if this is changed, it's going to change the outcomes for everybody in a positive way. So, yeah, I think as long as the wording is not necessarily a support for the legalization of marijuana, but it's a support for the Urbana City Council following the recommendations that have been handed to them by a community civic group that are based on research and that recognizes there's a racial disparity. Yeah, I can't see how we could not support that.
I didn't bring forth a formal statement, but I can start, I've started typing something, and I can start typing on the behalf of whatever comments you may have. Sounds like we need to say data-driven research, acting on recommendations of the task force, throw out some ideas, and we can come up with something and have a motion and go forth.
If I can just point out one thing, if you, particularly if people are nervous about mentioning or focusing on marijuana, that was just one. I mean, I don't know how much they're going to keep going, but actually, as of right now, there are 3 recommendations they're acting on. One, they lowered the fine for marijuana. The second one was committee of the whole on Monday night, sent to City Council for next Monday, lowering the fine for paraphernalia. And then the third one was really more about economic disparity, but it's part of the whole, it's coming out of that. It's also in response to the task force report of how the disparate impact, because of the disparity in income by race, that any fine amount has a disparate impact on minority population. And so I want to be clear, I think the recommendation is such a tiny change, it's not, it's really just more symbolic. But there was also, a committee of the whole passed to City Council a proposal to give people a longer time to pay municipal fines. And so, and not to even get to all those details, but I think you could, without focusing on marijuana, if we want to do a resolution like this, we could say that that the council has taken action on 3 of the recommendations, and then, you know, the whole idea that we applaud and encourage bodies to, when this work is done, to take seriously and to try to act on the recommendations, you know, something like that. But there are problems with that, which is, I think, what Pam wants to talk about.
Y'all love me, right? You may
I
not
do.
now.
Tell the truth, I want to hear it.
I'm struggling with this because we're talking about illegal conduct under state laws. And so the city council says, okay, they're not going to write city tickets anymore. That officer who was writing that city ticket is now just going to file a state charge. And so now we've made it worse because the paraphernalia fine, at least a couple years ago, was still $750. Oh, yeah. So I'm kind of, I don't know if I'm missing something here. I'll defer to the rest of you.
Pam, my response, this is something that the city council obviously had a hard time grappling with, was whether or not they could go against state, federal law. There will certainly be unintended consequences, as with any policy directive. But regardless of what the state law is, as I said before, the Urbana City Council looked at what they could do within their power, and they changed that. They changed their system to reduce the systemic racial disparities, a small part, and they're moving on. They're going to address others. So I think it's okay for us to still acknowledge that and call on other public organizations to do the same, including the state, if that's, you know, something we need to do.
And I think that's what this is about. It's not saying, oh, well, you have the unintended. If that's the case, what we should be talking about is the war on drugs overall. And so that's what this is about, but not to acknowledge an attempt to address disparities. It's like we're talking about apples and oranges. I mean, the very fact that it does not, in fact, impact the state statute is one thing, but again, we are acknowledging that the Urbana did what was within their purview. It brings up another issue then perhaps there should be some kind of conversation with the chief and directives to his officers in how to write tickets. That's a separate thing. But that, in my way of thinking, that in no way has an effect on, should stop the Urbana City Council from doing what they can, and should not stop us from acknowledging that they made an effort. Those are two separate things. So it's sort of like, well, I won't say that comment. Anyway, okay, I just think that it's appropriate and okay for us to acknowledge this addressing of a disparity based on the findings of the data.
Would we be able to also add a data component, like part of the recommendation would be, we hope that in a year, Urbana will revisit the data and see, did this dramatically reduce the number of, tickets by state, or, the fine amounts? I mean, potentially they'll see then that there are these unintended consequences. So we could just as a body say, that we're supportive of, continuing to examine the data ongoing.
My thinking would be at this point that we just acknowledge what they do. If we want to have those components, that could be in our report. I think we might be jumping the gun to do that. Now we're just saying, yay, good work. And so then I think it gets messier if we then follow it up with something else. Does that make sense? I'm thinking it could be in the body of our report, or just, well, anyway, that's the way I'm thinking about it at this point, because I think more people then would become apprehensive about what it is we're stating. So in that vein, I would like to make a motion that either Ryan or anyone who would like to work with him draft a statement to support Urbana's action and bring it back to this body.
Is this one of the times where we could offer public participation in this discussion, as we've talked about doing it throughout, before we move on a motion?
We could definitely suspend Robert's rules and ask for public participation at this point. Is there a motion? No. We would have to suspend the rules. Yes.
I move to suspend the rules to allow public participation.
Is there a second?
I second. Thanks, Esther.
All right.
Sit down. Wait, no.
All in favor of suspending the rules?
Aye.
All opposed? All right. Motion carries. We will suspend the rules. At this point in time, we would like to offer public participation.
Thank you. I'd just like to say that I think it's a very appropriate action for the task force to take, to acknowledge the actions that have been initiated by the Urbana City Council. And I also think the debate around the issue and the discussion has been really rich and productive in terms of trying to, move the progress of the task force forward. So I would say, well done, and keep pushing.
Thank you. Anyone else? Okay. All right. Well, we are going to resume our meeting. We'll call it back to order.
I would like to second Mariam's motion.
Okay, all in favor of drafting a resolution in support of using the Urbana City Council using data to reduce racial disparities regarding ticketing of marijuana paraphernalia and fines, say aye. All opposed, the same. All right, the motion carries. That's kind of a mouthful. Wow.
I said this 2 weeks in a row, but this time I mean it. I will draft a statement of support, but I would like any input via individual emails or phone calls or stop me on the street on specifically what that should look like. Yes, sir. Yeah, perhaps in the next week, I'll send a draft of what I'm working on. Please don't reply all, but certainly share thoughts, comments, feedback, and I'll work at what I can, and I'll bring forth on 2 Thursdays from now. And remember that we can also massage it a little bit more then and before we vote on it. So thank you. I agree with James. That was an awesome discussion, even better than I was hoping for. So I appreciate it.
And thank you, Ryan, for bringing it to our attention. Anyone else? Okay. All right, we are going to move to our next agenda item, which is presentations. Do we have a Dave Sutton in the room? All right. Dave, no Dave. All right. Well, we amended our agenda to include Barbara Kessel with Court Watch. Another person who was supposed to do a presentation, Sarah, was working with him.
Hello, I'm Barbara Kessel, and I'm going to introduce myself. I'm really daunted by the task of presenting to you because I have heard many of the presentations that have been made, and they have been so exciting and so good. And I really debated a long time whether I should take up this invitation or not, because I'm not a researcher, and my own view is just a worm's eye view as a volunteer at the jail and a court watcher. And I've had to put it together with a bird's eye view, which of course is what you need. And sometimes they don't match. So I'll do the best that I can. I made an outline and have handouts so you can follow me along. I have had a group at the jail called the Men's Movie Critic Club for 6.5 years. It meets twice a month, and it has 12 men in it. The waiting list is at least that long, 12 people waiting to get in, because once you get in, you stay. And so for someone to get in, someone else has to go, usually to prison, because the people I have been there a long time. It takes a while to get in through the waiting list. And so almost everyone that has been in the jail for like a year, sometimes even 2 years, I know them really well. That's my group. Court watching is related because Court Watch is a group that supports defendants who ask for someone to watch their court case. And the largest group we have is incarcerated people who can't go to court for their own case. They don't get taken to court unless they are going to trial or have a guilty plea, once in a while a motion. Usually they sit in jail for months, and these pretrials go on, and they don't know what's happening in them. So we go, we tell them, and we go to their trials. So that's who I am. That's why I'm speaking today. And I'm going to start with a true story from that group. It's about 3 years old now, this story. And this is written up in the first handout called Sitting in Jail versus Bailing Out, but you don't have to read it now because I'm going to tell you. A guy I call Alvaro, he was a Hispanic community college student, about 22, I think. He told me that he felt very bad about the decision that he'd made because his parents told him they could scrape together the $7,500 for his bail, or they could use the same amount of money for a lawyer, and he had to choose. So he chose to give the money to the lawyer, and he stayed in jail. Now, his case was that he had been apprehended by the police while sitting in an apartment of the guy that sold him the dope. And the two of them were smoking it, and the police came. Now, as it just happened, his friend, or his seller, whom I called Steve, he also could control just about that amount of money. They had the same bail. He made the opposite choice. He chose to use the money for bail, take the public defender, which is free, and then in the many, many months that followed, takes a long time for a case to come to fruition usually, Steve worked, made money, and at the very last minute switched from the public defender to a paid lawyer, a very common thing for people to do. And the end result was that Alvaro went to prison for 13 months after already serving many months in jail. The other guy, who was out all the time, got probation. They did exactly the same thing. In fact, the seller is more guilty because selling is more of a crime than possession, right? At the time, I was just astonished. This is 3 years ago. And I thought, well, I'll just keep that piece of wisdom in my mind in case anybody else has that situation, but no one else has. So I want you to move now to the second handout called 11 Facts That Will Change the Way You Think About Jails in America, and turn to the middle where you have a picture that looks like this. This was a bird's eye view that I didn't come upon for another couple of years, and it just ripped my mind open. This very figure. Figure 6, pretrial detention and sentencing. Compared to low-risk defendants released prior to trial, those detained before trial were 4 times more likely to receive a sentence of imprisonment than the person with a similar case who is out. This is exactly what Alvaro had experienced. His time in jail made it more likely that he would get a prison sentence. And they're 3 times more likely to get a longer prison sentence than someone committing the same crime who's free and gets a prison sentence. The bottom of that page, it says this is partly because most defendants never actually go to trial, but instead make a deal, and that of course is what happened with Alvaro. He didn't go to trial. Most of my people don't go to trial. 95% at least of the people in jail don't go to trial. They get a guilty plea. That's true all over the country. That's the game. And the deal involves pleading guilty in exchange for a reduced prison sentence. Inmates who are already incarcerated are also typically pressured to take a deal, even if it's not very appealing. Well, a lot of times I see that the people who are in jail and expecting to go to trial it keeps getting postponed and postponed and postponed, and they get more and more desperate until they're ready to take a plea. It's called sweating. Sweat them out until they're ready to take a plea. I talked to a guy just 2 weeks ago who told me his lawyer was a certain person who is paid lawyer and fairly good in court, I would say. But like most lawyers, not public defenders, but paid lawyers, they pressure their clients to take a plea because it's much easier for them than going to trial, which takes a lot of preparation, a lot of work, and so forth and so on. So this guy who feels that he is totally innocent, and if he's telling me the truth, he is totally innocent, he's been in jail for almost a year now, and he was scheduled for a guilty plea, and he was offered 2 years, and his lawyer thought that was really grand. But if you're innocent, that's not grand. That's not grand at all. So he is going to go to trial, and we'll be court watching for him. Number 8 there on the page you're looking at, it says when you leave jail, you're likely to be poorer than when you entered. Next page, a really important graphic. Incarceration reduces earning power. Estimated effect of incarceration on male wages, weeks worked, and annual earnings predicted at age 45. And this affects you your whole life, spending time in jail. It says at the bottom, spending time in jail can cost you your job, your government benefits, and leave you with mounting debts. It can also make it harder for you to get a new job, as employers are wary of hiring people who've been incarcerated. And number 10 on the next page, bottom line, even if you're released quickly, a short stay in jail can really mess up your life. And I have seen this in terms of people who are only incarcerated for a couple of weeks. If you have a low-wage job, they won't keep it for 2 weeks. They won't keep it. If you have a professional and you're in jail for 2 weeks, you could come back to your job, but not if you're a pizza delivery or something. You miss 1 day, you're done. So you lose your job when you're just in jail for 2 weeks. That's really nice. But you come out without a job, your family is usually mad at you, often, or your girlfriend. So you can lose a whole lot from just a little time in jail. And even more if you're the kind of person who never expected to find yourself in jail. Number 4 is a tiny excerpt from an article called Freedom and Money, Bail in America. Now, this blew my mind also. Actually, everything I'm giving you are things that kind of exploded my brain when I bumped into them. I was amazed to discover fairly recently that there is a place in the United States where there's no bail. No cash bail. And it's Washington, D.C., of all things. So here is a little description on this one-pager of what it's like with no bail. And it turns out, and I've read several different articles, I just went for one that would give it to you in a capsule, but basically, they get the same results in terms of people showing up for court, which is the whole point of having bail, or committing another crime, which is the other point of having bail, public safety, no different than our system, the rest of the country, where there's enormous amounts of money coming and going, supposedly to guarantee that you'll show up in court. It makes no difference. And for public safety, I've been noticing since recently, I have to read the papers to find people who are dangerous who are let out on bail because they're not in my jail group. They're out. There's some very dangerous people who are able to afford high bail, and out they come. They can put up their house for $25,000. Pam's shaking her head. Yeah, there. So bail it's sold to us as the idea that it's protecting us from dangerous people. No, it isn't. Or that it's necessary to make people show up in court. No, it isn't, because they know if they don't show up in court, then they have to go to jail. Next handout. Now we're going to get down to our jail. I have a little one-pager here called Merged Arrest Data Tables. And this is following up on what Chris Evans told you last time. He reported on 3 months' worth of bookings and what the relationship was racially, the demographics of people booked into the Champaign County Jail. This is a product of some research done by the University of Illinois students that was done for a report on representation of race and gender in News Gazette crime coverage. And in order to do this, they had to get from the sheriff, they had to get all the statistics on who was arrested and who was booked. And last time, when Chris was giving these figures about bookings and arrests, I think it was Esther who asked, what about warning tickets? Who is it that doesn't get booked? You know, there's a big gap between people who are arrested and people who get booked into jail. It's huge. Well, here we have it. This is another mind blower. I wish I could have sort of put this in a graph so it was easier to understand, but if you look at the arrest data by race, you have 2003 black people. This is over a 3-month period, which is last summer to 2015. 2003 black people and 435 white people, 557 other, 21 unknown. Then when you go to bookings, suddenly the proportionality is very different. 833 black and 564 white, 90 other. And in percentage points, when you go down to the second half of the page, you have 39.9% black arrested, 55.6% booked into jail. So this isn't the police, folks. This is not the police. They do the arresting, they hand the people over. This happens in the sheriff's jail and in the arraignment court. So there is something to really look into. Then I was really upset. This is the next page now. I was upset when I went home after Patsy Petrie gave you some data at the beginning about the jail, and it was supposed to be everyone who was in jail on August 17th of 2015. And she made the statement that everyone in the jail was really dangerous. And I looked at the data, and it looked like they were really dangerous. And there was no traffic. There were nobody. And somebody asked the question, one of you asked the question, well, where are the traffic cases? And she said, there is not one person. That's a false myth. There's not one person in jail for traffic. Okay, so last night, in the middle of the night, I decided I had to just look into this. So I got into the sheriff's pages, which I'll tell you a little secret. If you go to the sheriff's pages, they're public, and you put somebody's name in, you see that person. But if you sign the little CAPTCHA and you don't put anyone's name in, you get the entire jail population. In the order of from right now down to the last person who is the oldest one, the veteran. So when I started last night, the first person had been booked a half hour before I was sitting at the computer looking. And I had the patience for just 60 people, which is about a third of the people that were there. And going through those 60 and just looking for people with traffic violations, I saw these. Now, I got 15 cases out of 60 are traffic. And chips, you'll see chips there. That means electronic monitoring device. And there are 6 of these. DS or RL license means suspended or revoked. I was trying to think what the D is for. Driving, thank you. Driving on a suspended or revoked license. So the first 3 are given chips. The next 2 are put in jail. And there's no difference that you can see. Maybe there's a record difference, background.
Chips are already sentenced. The ones that are jailed probably haven't been sentenced yet.
No, they have, because there's a release date. Do you see the release date? That means that it says on their page that they have to stay in the jail till the 17th of May or the 6th or the 7th of June.
My guess is they've either had chips in the past, because they only get one shot at it usually. And if they
That's right. That's right. I just found that out recently. You can only have an ankle bracelet once a year. So if you get caught on another traffic, you got to go sit in jail. And that's the sheriff's idea. I mean, it's not a law. It's just his idea. And maybe it's because he's in charge of those people with the electronic monitoring. He has to send a deputy to their house every week. So that's why they're listed in the sheriff's pages, even though they're not in the jail. They're his responsibility. But when it says no jailed, that means no chips, they're in jail. Then when I got done, I sort of wished that I had looked for all the other things that were low bail. So I went back quickly and I found that there were 5 cases in the 60 with bonds from $500. Imagine that. You could get out for $50 and this guy can't get out. $500 and he's sitting in jail. And then to $5,000, which would be a bond of $500. So those would be considered really low bonds. And 2 cases that have no bonds because they're going to drug court. And they have to stay in jail until there's a bed available at Prairie Center. And I've had guys in the movie group that were there for 2 months waiting for a bed. They're in jail. That's drug court. So this was to the point of saying, no, not all the people in jail are real dangers. They may have done something wrong, but they're not all scary criminals. And finally, your last 2 pages, these are straight from the sheriff's pages with the person's photograph and address deleted. These people are currently in the jail, and I know them. And they look really scary. Armed violence, armed habitual criminal. That's about as scary as you can get. Armed habitual criminal, the first time I heard that word, I thought, what? What? And then I found out that it's a legal term, meaning that you have been caught 3 times with a gun crime. And a gun crime can just be possession when you are a felon, ex-felon, and then you come in contact with a gun. It's too bad. So armed habitual, you're supposed to have 3. I want to tell you the stories that these people have told me about their case. And I cannot tell you that it's the truth. I won't know what the truth is till I go to their trial or guilty plea, and even then I may not. But I know that sometimes people's stories are true. And so I'm going to tell you what they told me. So the first one, age 48, race black, $250,000 bond. Now that's $25,000 that you have to come up with, okay? He's been in jail for a year in June. He told me he is a minister of a church, works with youth, has a wife, 4 kids, grown, I suppose. And he was convicted and served time 22 years ago. And in between, well, he told me he didn't have a gun in that crime that he was convicted of 22 years ago. So he said, I haven't anything on my record since then. I don't know why this is a armed habitual. So I checked him out. I looked up on the website, and he has a couple of cases that do not involve guns, one of which was dismissed and the other he was acquitted on. So they really don't count anyway, but they didn't involve guns. So I don't know. You know, I just don't. It's wow. So I said to him, well, what actually happened? You know, how did you get into this situation? And he said, well, the police came to my house with a search warrant, and they had a confidential informant. I said, did you know who that is? And he said, yeah. I saw the name on the police report, and it's a local drug addict who, reports to the police, confidential informant. They use this in the drug war all the time. And so they came into his house. He wasn't at all worried because he had nothing in his house, he thought. But upon searching, they found 2 jackets with guns in the pockets of relatives who were visiting for the weekend from Chicago. Young men. He didn't know they were there. He has been in jail for a year, waiting. And his lawyer, as I told you before, this is the case I was referring to, his lawyer wants him to take a plea deal for 2 years. He's going to go to trial in June. Now, suppose he is acquitted, and this, I wouldn't be surprised. I've seen some of those trials. No one's gonna give him a year's wages. No one's gonna say sorry. He has just spent. Now, why wouldn't a pre-trial risk assessment instrument say this man has a good job and a family, will let him be free while he waits for his trial? You would think. But we don't have any pretrial risk assessment working. As Lynn Branham told you, we don't have any. So it's arbitrary. The other person is 26, black. He's been there even longer. It'll be 2 years in September. What actually happened, his bond is $50,000. What actually happened with him is that he shoplifted a battery and phone charger from County Market. How did it get called armed violence? Well, when he was apprehended on his way out of the store, which is important, he was, out, I think he had his foot out the door. This is his story. The manager took him into a little room and said, we're going to put you on a no shop list, which is, I didn't know about this, but that's what they do with shoplifters. You get a no shop list, which seems reasonable, and you can't shop there anymore. So to be on the no shop list, he had to give his driver's license. But he didn't have it with him. He claims he had one. I don't know if he did or not, but he didn't have it with him. He didn't have a wallet with him. So the manager said, well, I'm sorry, I have to call the police. They called the police. Police came and patted him down. They found a gun in his pocket. Okay, now he's in big trouble. However, he didn't commit armed violence. He did not commit armed robbery or burglary because he didn't use the gun in the process of shoplifting. The difference is retail theft, which is a misdemeanor, and armed burglary, which is a felony. The difference between those two is entirely up to the state's attorney to decide. Now, a few years ago, some graduate students did a little study on women in this county who were guilty of shoplifting. And they found that all the black women were charged with felonies, all. And the white women were charged with retail theft. State's attorney's option. So they had the opportunity to ask her, how do you explain that outcome? And she said, well, I don't know the race of the people. I don't even look at their pictures. I have no idea what race they are. I do it by priors, meaning your record. Well, now that brings us back into the police action. You know, if you were picked up for jaywalking as a kid, which is a crime only black kids commit apparently around here, then you start building your record of priors. You get into juvenile detention and so forth and so on. So who has the priors and who doesn't? It's a cumulative effect of the whole system. So I wanted to show you these two cases to show you that when you look at that sheet that they gave you, that the sheriff put up, and they say everybody in jail is dangerous, it's not right. It's not right. That's all I have to say. Any questions, comments?
I have a question. Oh, yeah, first, just a comment. I don't have it in front of me, but I looked at that list quickly because I was very surprised when Patsy said that. And I saw several shopliftings, and I saw an obstruction of justice. That's a person freaks out when they're being arrested for something
Right.
they didn't then end up being charged for, but they gave a false name.
Right.
So I feel safe with people who give false names when they get arrested. I mean, that's, anyway. But I'm curious about, what you said is really important, which I see it's real important. If you could just walk us through what booking means, because if I'm arrested driving home tonight, I'm going to be taken to the jail, and I'm going to be put there in the holding cell. So I am in jail, but I am
But
not,
you're
I'm
not
arrested, but I'm not booked.
Booked, right.
I'm booked after arraignment tomorrow at 1:30. I mean, if I can't bail out tonight, so I'm over, at what
You know,
point?
Pam is the person that
When
can
am I
answer your
booked? That's
question.
why I want to just look at these numbers. The differences are so great. What is booking? Is booking that charges are being brought against? No. What is it?
When you're taken to the jail, then you're fingerprinted and you're booked. So everybody who's taken to the jail is booked. So I'm not quite sure what you're meaning, the difference between the arrest. Now, when you're stopped at a traffic stop and they've stopped you for speeding, technically, you're stopped, you're arrested, but then you're released on your ticket, whatever.
Right.
Kevin, would you agree with that?
I would, additionally, I think that there might be, I mean, I've also seen several people who have what would be termed, what would basically be a bookable offense where they just give them a notice to appear.
Right.
So maybe we're talking about, here's your notice to appear offenses.
And
That's
that
what
would still, I think, be an arrest, but they're not taken to the jail and booked.
That would be my guess. I would guess these are people where you go, here's your notice to appear, your court date is this date, you need to show up.
But
So-
then they're booked later. They're booked after arraignment court when they show up on their notice to appear. Then they have to go out to the jail and report out to the jail on a certain day and time, as I think how they're doing it now. And then they go and they get there, so that they almost always have the goal is to get fingerprints on everybody.
But
So-
to be fair, I would just like to point out that if they get the notice to appear and then they have a specific booking date, it's literally, oh, I get to go in and it's an hour as opposed to being all night, stuck in a holding cell or stuck in jail, not knowing what's going to happen. Additionally, we're also talking about these people aren't people who now can't show up for their job the following morning. And I think, obviously, you know that. I just wanted to make it clear for everybody.
So just, wait, if you just clarify then, if 2003 African-American people were arrested and, whatever, almost 1,200 of them didn't get booked, the question is what happened to, what happened to them all? And so if I'm understanding correctly in terms of the use of terms here, the arrested person gets taken to jail. Or no, they don't, no, I take it back. That what you think this discrepancy might be are all traffic, notice to appears, that 2003 people were either arrested and taken to the jail or given a ticket. No, that 833 of them were arrested and taken to jail, and the rest of those 2003 were just given a notice to appear.
And
Is that what this number is, or is this?
I don't know.
You know, what is the source of this information? Because these numbers, I see they're important, I just want to know what they are.
Yeah.
Where'd you get it? That we can look at?
That's why I put this down at the bottom, representation of race and gender in the news, because that's the project, and it's sponsored by the Klein Center of Democracy. So if you go to the website, Klein Center of Democracy, you'll see this full report. I got it out of the report itself.
Okay. And that was the News Gazette, that was a report on the,
That was
Pic-
about
the-
putting pictures in the
Pictures,
paper.
I went to that
Yeah,
presentation,
that was
okay.
their point. Mine
Yeah.
was
but but you're saying that the Klein Center of Democracy will hopefully answer this question for us about what they mean by arrest and jail bookings in this context.
It
Is that
didn't
right?
answer it for me.
Oh, it didn't?
No, I really don't know.
Maybe Vera knows?
Do you know, Dottie, more?
May I? The link to this report is in the packet that we handed out, I guess, a month ago now. And the data that I had on notices to appear for several years, it was in the range for the whole county of about 500 to 700, somewhere in there. So there's some other numbers involved, and some of it might just be like a speeding ticket where they don't need to. I just don't know.
So do you know the difference, do you know what this means by jail bookings versus arrest? No, okay.
When you get arrested, because it's possible for you to be arrested and appear in arraignment court the same day, and then you're not going to end up getting booked necessarily because you post your bond and get out. You'll still go get booked officially, but some of that can happen, and that would be an arrest, but not a booked in the jail situation.
Well, then again, would you clarify, maybe I'm making this too complicated. Is booked in the jail mean that at arraignment, you went to arraignment and they didn't drop the charges? Is that, or is it booking, I mean, as soon as they arrest you, they take you to jail and they fingerprint you and put you away. That is, if that's booking, then arrest and booking should match 100%. If booking is what you're talking about, that after the arraignment, if they didn't drop the charges, then you're booked, these numbers would make sense. But the expression booking refers to when you're first fingerprinted, yeah? Or it's different?
Just for an example, one of the must appears would be that you can receive might be no proof of insurance. You can literally go to the first thing, show your proof of insurance to the prosecutor, and the prosecutor will dismiss the charge then and there, and then you wouldn't be booked. That would be one example where I think it would qualify as an arrest and then not a booking.
And that would be, what if they put me in jail, kept me there overnight, and then I had to get someone bring me my insurance card in the morning to prove I have it?
They wouldn't generally, well, then that would be a booking because they wouldn't keep you in jail without booking you.
Okay, so everyone booked is kept in jail.
Right.
Yes.
So the discrepancy between arrest and booking has got to be notices to appear that don't involve taking you in.
I mean, there's sort of a group, although I'm not sure what they classify as arrest versus not. I think that's really the issue. This is just data that was handed from the sheriff's department, to my knowledge. So, I mean, I think that as far as arrest versus booking, I don't know how reliable this information is, although based on just my anecdotal experience, I would say that there is certainly a significant difference in, or there's certainly a significant racial disparity in how bookings happen, how whether it be from the determination of handing the ticket, the actual arraignment or otherwise. But I think that I don't know that this actually is the proper data, basically because I don't know what the sheriff's office termed an arrest.
Yeah, this is a result of a FOIA to the sheriff, these figures. I noticed when I did this little quick and dirty thing last night that there were a whole bunch of people that never went to arraignment court. They were no bond people. You see that all the people that got chips, they had no arraignment in their.
They maybe were arrested, and usually it would be a traffic. So it's a driving unsuspended. They're usually arrested though, but it's discretionary. The cop doesn't have to arrest them. But they usually do. And then they get out during arraignment, they post bond, whatever. The chips is their sentence. You don't get chips until you're sentenced.
But who gives them the chips?
Okay, the state's attorney has to agree to it, and the jail has to approve them.
But there's no judge?
I'm trying to think if the judge, it's been so long, I'm not sure if the judge has to go along with it, if the judge is even part of it, or whether it's something that's put in the plea that they get X amount of days in jail, but they can serve it, or they're eligible for chips. I've seen it where they have to do 30 days in jail and they can do the rest of their 180 on chips. So I've seen that.
But where does it come from?
Well, it's a way to move people out of the jail, to reduce the jail population. And it's statutory.
But no judge says it. It just
I can't
somehow happens.
I can't remember for sure if it's part of the plea negotiation, or if the judge has to agree to it, or whether it's just something between the jail and the client.
I don't believe the judge actually agrees to it, but there's some specific, I mean, because of the statutory requirements, what you're looking at is usually, I mean, in my experience, when I negotiate a plea, it's usually with an understanding of what would qualify for chips and what wouldn't. For instance, you don't qualify, I noticed one of these was like 8 or 9 days. That automatically wouldn't qualify for chips because it's less than 10 days. So that might have been one of the there were, I believe, a couple that were jailed that you had mentioned, but the sentence looked like it was less than 10 days, so that's not going to qualify. Additionally, you'd mentioned you can't do twice in the same year. So I mean, there are some very specific requirements. The judge doesn't have to approve it, but they have to apply for it with the sheriff's office before they even get the sentence. So they know when they plea whether they're going to be able to get the chips or not.
And they have to tell the judge that.
Yes. So the judge may take that into account with whether to accept a plea or not, but the judge isn't determining whether they're on chips or not, other than saying, I'm not taking this plea because I don't think this person should be out, theoretically. Although, in my experience, it would depend, I haven't been in front of the new traffic judge, but with Judge McFeeters, it was just sort of a matter of course with how it worked.
And I think that's true because they're trying to keep the jail population down. We get all kinds of emails between the offices, the sheriff and the state's attorney and the PD's office. When the numbers get high and we're running out of room, you know, we've got to move these people, whether it's through bond reductions or whether it's through chips or whatever. So that's always, as the numbers go up, then the emphasis is
So the
how do
bond
we
is
move
used to control the population in the jail? That's what I hear you saying.
Well,
Yes.
kind of, yeah.
Honestly, I would like to think no, but what happens is sort of the way it works is the determination of bond is almost always made by the prosecutor, and what happens is if the state's attorney gets notice from the sheriff's office, hey, you know, we're really full up, then, you know, maybe the state's attorney allows more, just more released on their own recognizance, you know, lower bond in general. But I think the reality is yes.
So if you built a new jail and you'd have more room, you would never have to lower the bond and you could fill it up.
Oh, no, no. The county would fill that up and then we'd have to lower the bond because all the beds would be full then.
Kevin, could you address on the chips? You said these were statutory requirements, the 10 days and so on. Are you talking like local statutory?
No, state.
So in other words, this is not their discretion. This has to be.
Whether somebody qualifies for chips or not is not really local discretion. I mean, because the basic, but whether they qualify for chips or not can be at the prosecutor's discretion depending on what they're charged with.
And this idea of once per year, though, that's local?
No, I believe that's state. I believe that's state. I'm not 100% for sure on that.
Okay, got it.
I have a question. Barbara, I don't understand this. You said that people can be put in jail and accused of things, but then they're not even present in the court when their cases come up?
No, it's the
What?
pretrial. The pretrials are where if you were free, you have to come to a pretrial. And the pretrial, I wrote a whole article on this called Cattle Calls versus First-Class Justice, because the cattle calls are where the public defenders come with their clients, and the first-class justice, that's my term, is where the paid lawyers go with their clients. And the people who are in jail don't get to go at all to their pretrials until they are required to say something, which would be a guilty plea, you have to be there and you have in person, or a trial, then you are brought over. But in the meantime, you could sit for 6 months and never see the inside of a courtroom, right? And your case comes up over and over again. Now,
Wait, what happens at a pretrial?
what happens at a pretrial is usually a date setting, and at first, when I went to them, I was like, what is the point of this? Everybody just gets out their
schedule.
calendars and comes up with new dates and so on. But eventually, I learned that there is a little drama in who asks for a continuance, the state or the defense. Because if the defense is trying to push for a speedy trial, they can't ask for a continuance because that resets the clock as soon as they ask for a continuance. So all continuances must come from the state. And in the case of this young man that I talked about, the shoplifter, he was counting on his speedy trial clock coming up because he has been in a long time. And all of a sudden, I read in the court transcript that they made a correction on a previous date, 2 months before, that it wasn't the state that asked for a continuance, but it was his attorney that asked for a continuance. And nobody in Court Watch had it in their notes. And we just beat ourselves up. I mean, because I don't believe it. I think it was falsely corrected. I think what happened is that the state asked for the continuance and not the defense, and then the state did not want it to to hit the speedy trial bar, because then the case gets dismissed.
If a person's in jail and and he or she believes he's innocent or she's innocent, why would they, and they're already in jail, why do we have to set a date for another trial? I mean, for the trial, if they're already there, why can't they just go ahead and say, and meet the first time?
Pam?
All right. For the PD's office, and our rules are different than with the public defender's office. Our rules are different than private attorney cases, but Judge DeFanis has indicated that there won't be continuances unless there's really legitimate, I mean, you can usually get one continuance, but after that, you've got to be waiting for lab results from the state lab. That could take 6 months. Okay, if there is something there, the backup is so long, and at one point it was almost a year. So sometimes that's what the delays are. That's going to be a joint motion, or it should, no, it should be the state's motion. I take that back. It should be the state's motion. But so for the public defender's office, you're usually, once in a while you will if it's a murder case or something big like that, but usually you're not going to see misdemeanors hanging around. I would continue them one time and that was it. We were going to trial or that was it, because it's ridiculous. Same way with the lower level felonies. Now, if you're getting into a class X where they can go to prison for 30 years or 60 years or whatever, then that's a whole different ball game. But for the most part, if you're ready and everything is ready, then, you know, those cases should move. Private attorneys, though, I've seen them go in and, you know, oh, well, it's continuance, move to continue. State's okay with it. Some of the judges will say after 3 or 4 times, nope, no more. Other courtrooms, yeah, okay, we'll just let it limp along. So part of it is the courtroom that you're in, part of it are the attorneys that you're dealing with, the state's attorney that you're dealing with. Part of it is how many people in jail are set for jury trial this time in this courtroom. And then whoever's been there longest is going to go first because of the speedy trial thing.
So you talked about private attorneys and asking for continuances. Is that because their clients are already out and they just
Not
wanna
always.
Why do they ask? The same reasons? or-
Money.
Money.
I wasn't going to say it.
I was typically the
Oh,
reason
yeah.
why I asked for more continuances, and I don't represent a lot of people who are already in jail. Most of mine have bonded out or got no bond anyway. Typically, what I've asked for continuances for are either I want more time to negotiate with the prosecutor for a plea deal, which happens quite a bit. And one of the main differences is that honestly, I can generally speak to my clients, and the public defender just doesn't have time, doesn't have access, and a lot of times those pretrials are when I speak to my clients, and so I'll speak to them and I'll say, okay, the prosecutor will hand me a packet and I'll say, here's what we're offering it, and I'll go and look at it, and then I'll go and discuss it with my client, and then I'll come back to the prosecutor and say, I think you can do better, or here's this particular issue that I think we're strong on, and I think we need a better deal than this, or we'll take it to trial, and that's where the majority of the plea negotiation actually happens.
With the public defender's office, I don't know what they're running now on felony cases. 12 to 15 years ago, I had caseloads, pretrial cases, the cattle call, where I had 50, 75 clients at one call. You cannot talk to them and have a meaningful discussion with them at pretrial. And that's the number that would not be in jail. If they're in jail, they're a captive audience, and I can pick up the phone, or I can go over and I can see them. Those we can get resolved. But if they're not, and they don't come in to see us, and that's one big, if we do nothing else, we need to get education out in the community for clients of PD, of the Public Defender's Office. They have got to go and talk to their attorney. We cannot help you if we cannot talk to you. And you showing up 5 minutes before court expecting to have a conversation about the facts of your case and the evidence and, you know, the strength of your case and the weaknesses and all of that, you can't, that's an hour conversation. That's a half-hour conversation. For me, it was an hour conversation. I talk a lot. But bottom line is, you know, you can't do it effectively. But we're working with a group, with a group of people that are struggling to survive, and they're prioritizing, and they're always triage. And I know that because that's where I came from. That's what happened. That's when I was going to school and all of that with my kids, it was triage. So I understand not being able to prioritize in the way you should, okay? Sometimes it's a mindset, and trust me, 30 years later, I still struggle with that mindset sometimes because it is so ingrained. It's not an excuse, it's an explanation. And what we need to get people to do is understand that they need to come in and take the time and make it a priority, because that's how how public defenders can help you. Private attorney people, you're paying them, you're going to get your money's worth, hopefully.
Not
Okay?
necessarily.
Well, theoretically.
But we've gotten pretty far from your question. I think the point is that if you are innocent and you are in jail and you don't want to plea bargain your way out, which a lot of people do, they just say, I can't sit here for another month. I will lose my child. I'm going to take a plea, even though you're innocent. But people who say, no, I'm innocent, I'm going to go to trial, they're just going to have to sit and sit and sit. And part of the process is with all these pretrials, and part of the process is purposely waiting so that the person will break down, so that they won't take a trial, because they couldn't try everybody. It's not set up that way. But the hard part for you is to tease out the issue of green from black, because they are really very overlapping here. That's why I talked about the issue of no bail. That would help so much. And the good news is it's starting to happen. It isn't just Washington, D.C. There's really a movement afoot to make this spread to other parts of the country. That would be huge.
And that would be tied to that other recommendation you were talking about, or you weren't saying it that way. The pretrial assessment analyzes the risks of who should be kept with no bail and who should be released, period, those two options.
Right,
So those
right.
two are tied together, right?
Well, they're not tied together. You could do one without the other. They're not that tied together.
But they help each other.
Well, and I want to warn you about pretrial assessment. I wish Lynn Branham was here tonight because she's really the expert on this. But from what I've read recently, that may not be the cure-all that it looks like from the beginning. Because if you say, okay, we're going to let people go that have a job where they make more than the minimum wage, or we're going to let people go because they have family support and everything, and you can end up letting more people who are white go than black just because of your criteria. So you have to be careful that, and I don't know if you would have influence over that. Lynn knows what there are different kinds of pretrial assessment, but just the word doesn't mean that you're going to cure everything in terms of racial injustice.
By the same token as your presentation, I would like to recommend that any member of the task force who is interested in this issue might want to watch. There was a Last Week Tonight with John Oliver that specifically addressed bail and how it was set. And I think that did a particularly good job in showing some of the inequalities and some of the issues that do apply to this community.
One thing you've got to remember is the judges look, when they decide whether to set bail or not, they look at how many failures to appear you've had. So if they have had even one failure to appear, they're not going to get recognizance unless it's a Class B or a Class C misdemeanor. They're going to have to post money. And there's, so it's important people make their court dates. If they don't, they're screwing themselves for down the road.
Now, one last thing I learned, again, in a sort of mind-blowing way. I didn't realize that there were two kinds of pretrials. I'd been sitting in them for years, and I didn't know that there was a difference between the public defender's pretrials, which are called cattle calls by the lawyers, not me, and the private attorney's pretrials. And so one day I was sitting in what was a private attorney's pretrial, and the person I was watching for wasn't called. It wasn't that she didn't show up, but she just wasn't called. And so I turn. Oh, I know. I'm sitting there, and suddenly Judge Ladd calls for somebody's name, and the lawyer stands up, and he says, well, so-and-so isn't here because he went to Chicago last night. And Judge Ladd said, well, why doesn't he come back from Chicago? And the lawyer said, well, because he didn't have enough money. And I thought, well, that is the oddest answer. If he had enough money to get to Chicago and he knew he was supposed to be in court today. Anyway, Judge Ladd said, okay, how's next month? July 23rd. And I thought, wow, that is the oddest thing I've never seen. Usually the judge bangs their gavel and says, warrant. The person isn't there. Okay. Yeah. So the next one, about 2 more people go down, and the state's attorney says, so-and-so's not here because she is out of the country. And I went, whoa. And Judge Ladd said, fine, let's give him another date, I was just in a state of shock. And I turned around, I was going to whisper to my neighbor, court watcher. And as I turned, I was sitting on the front row. I said, Laura, we're surrounded by white people. Because the courtroom was full of white people. I had never seen that before. And I thought, no, they can't. They couldn't possibly have separate pretrials for white people and black people. That's not possible. How does this happen? So I went up to the bailiff when it was all over, and I said, where was the case of Susie Smith? And she goes, well, she's not on the docket for today. Was she in the, maybe she was in the cattle call down the hall. I said, what? And that's when I learned that there are 2 kinds of pretrials. And when I told Randy Rosenbaum about this, I said, when did this happen? He said, oh, it's been now, they've done this for years, but it doesn't make any difference. He said, there's no difference. I said, yes, there is. If you have one of these paid lawyers and you don't show up, they'll make an excuse for you and everything's fine. If you got a public defender, you got a warrant. Now that's a big difference.
That's not entirely true. The way my guess is with those particular things, what happened was the attorney had previously talked to the prosecutor and specifically said, hey, here's what's going on, and got approval for a joint motion to continue.
Oh, right, with the guy that was out of the country. But the first one was spontaneous. The man had just gone to Chicago the night before from drug court. That's what the lawyer said. And Judge Ladd said, why didn't he come back? And he said, well, because he didn't have the money.
I've honestly never seen that happen. So.
Okay, we're going to take one more question. If we have any more questions or comments. All right. All right, thank you so much for coming in and presenting. All right. Our next agenda item is just any task force member comments. Any comments?
I move to adjourn.
All right. Good night. We are so adjourned.